The progress of this Criminal Procedures Reform and Modernisation Bill has been a fascinating insight into the politics of compromise. I want to say from the outset that the purpose of the bill is one with which we in the Māori Party have no argument. The intention of the legislation is to simplify criminal procedure and provide an enduring legislative framework that is fair, reduces unnecessary delay, is flexible and able to take advantage of technological developments. The Māori Party supports an efficient and effective justice system. By implication, therefore, the party supports the bill's overall aims of modernising and speeding up the criminal justice system while ensuring a defendant's right to a fair trial. This last issue, the right to a fair trial, is of course where the politics of compromise has come to the fore. I refer to a quote from Gilbert Chesterton that compromise used to mean that half a loaf was better than no bread. Among modern statesmen, it really seems to mean that half a loaf is better than a whole loaf. Unfortunately for Mr Power and his government, but fortunately for the Māori Party, that is very much the case for this bill, that half a loaf is better than the whole loaf. Mr Power has had to significantly compromise the substance of this bill in the light of concerns raised by the Māori Party and of course other parties around this House. And we want to acknowledge the spirit of cooperation demonstrated by Mr Power in his negotiations with us and the efforts that he went to in order for this bill to proceed. And so we welcome the decision to remove the requirement for a defendant to identify issues in dispute before the trial from the bill. This is the right to silence provisions. The half loaf for Mr Power has meant retaining the right to silence, lowering the jury threshold from 3 to 2 years and changes to rules about non-attendance in court. This is much better than what was originally conceived, which removed an accused's right to remain silent and not have that held against them. The Māori Party could not support Clause 64 of the bill, which requires a criminal defendant to disclose their defence to the prosecution before trial. In making our position clear, we were guided by the United Nations Declaration on the Rights of Indigenous Peoples, particularly Article 1, that Indigenous peoples have the right to the full enjoyment as a collective or as individuals of all human rights and fundamental freedoms. The original form of the bill eroded the right to be silent and would have made Aotearoa one of the few nations in the world to take it away. The other major issue for us was around the ability of the court to proceed in the absence of the defendant. Of course, it is much easier to convict someone if they're not present to defend their case. But for us, it is a matter of out-and-out justice, the right to be heard, to defend yourself. It is hard to understand how government could expect to gain support for hearings proceeding without the presence of the accused. The Attorney-General concluded that the particular provisions reversing a person's right to be present at their own trial were inconsistent with the rights affirmed by Section 25E of the New Zealand Bill of Rights Act. This section is around the minimum standards of criminal procedure, and it states boldly that everyone who is charged with an offence has, in relation to the determination of the charge, the following minimum rights: the right to be present at the trial and to present a defence. Partway through the negotiations, the Minister of Justice attempted a partial accommodation by seeking to replace the wording "must proceed" in clause 128 with new wording "may proceed." The Māori Party was not satisfied that the proposal was sufficient to allay the concerns we had around the trial in absentia proposal, and so we advised the Minister that we could not agree to the inclusion of such a contentious proposition. We felt we were on good grounds. And I return again to the comment of the Attorney-General. The right of an accused person to minimum standards of criminal procedure is a fundamental human right recognised by Article 14 of the International Covenant on Civil and Political Rights and affirmed in Section 25 of the New Zealand Bill of Rights. While no doubt the intention of the proposal to minimise delays and reduce inconvenience and stress to victims is one that we can fully understand, it does not justify moving away from the basic human right that defendants need to be present to ensure that they are aware of what the case is against them for a start, and then how their case is proceeding. In sum, we have been strongly opposed to the notion of presupposing a trial can be undertaken without the accused being present. While we understand and appreciate the frustration of delays caused by defendants failing to attend a court hearing, we believe that the right for a defendant to be present at trial must be protected. There must be other approaches that can be taken to ensure defendants are in attendance other than resorting to the most draconian measures of a trial proceeding without the accused being present. In light of our concerns, we were pleased with the compromise position from Mr Power that would limit the discretion of the court to proceed to only procedural hearings, that is, only those hearings where no determination of guilt or innocence will be made. Finally, in reference to the punishment of counsel's use of order costs, we take note of the advice that the court already has some limited discretion to impose court costs on counsel and defendants who fail without reasonable excuse to comply with procedural requirements. We believe that there are sufficient professional avenues in place to ensure high standards are upheld by defendants and lawyers. We do not support the punitive approach of threatening costs, as we cannot see that such an approach will in itself encourage better practice. We do, however, share the concern of government that lawyers must be able to be held to account for the services they provide for their clients. But we do suggest that the professional associations are the right and proper body to do this. Given the provisions are already evident, we do not accept that there is any need for the cost order provisions contained in the original bill. However, we have accepted the compromise again put forward by Mr Power in terms of amending clause 361 to make it clear that such orders are expected to be used rarely and only for significant procedural non-compliance. According to the Minister, this will set a very high test for the judiciary in deciding whether to make a cost order. The final point of concern is around the jury trial threshold. The bill originally sought to raise the threshold at which a defendant could choose a jury trial from offences carrying a penalty of more than 3 months' imprisonment to those carrying a penalty of more than 3 years' imprisonment. It was noted that this one change might result in up to 1,400 fewer cases needing to be designated for trial by jury. Our concern, however, was that best expressed by the Dunedin Community Law Centre that the removal of the right to trial by jury may mean that for some people they may think that justice has not been served and may feel vulnerable having a sole judge grant the power of a prison sentence. The Minister has removed the exceptional circumstances test and is now proposing to set the jury trial threshold at 2 years, which, whilst not optimal, is still better than the original 3 years proposed. Mr Speaker, we want to ensure that the reforms will ensure more timely justice for victims, witnesses, defendants and the community. We are confident that with the changes accepted into law even under compromise will allow us to support this bill.
I call the Honourable Member Simon Bridges.
Speaker, this is an excellent